All right. Thank you very much, Eileen. Um, my name is Dave Kingsbury. I am the Director of Deaf Services for the Missouri Department of Mental Health. Welcome to Understanding the New ADA and Section 504 Web and Mobile App Accessibility Rules. If you're interested in learning a little bit more about the Department of Mental Health's Deaf Services, I'd invite you to go to dmh.mo.gov/deaf services. I also wear several other hats, including serving as web accessibility coordinator for the department. So in today's presentation, we're going to cover the big W questions. We're going to look at why a new web accessibility rule was published, who is required to comply with the rule and by when, what technical standard must be met, what content must meet the standard. We're going to talk about some exceptions to the standard. And then at the end, I'm going to share some resources and references for further study. Now, this is a text-heavy presentation. That is intentional due to the nature of the topic and how thoroughly we're going to cover it. This is an in-depth presentation on a fairly technical topic. I've tried to simplify things as much as possible while also maintaining technical accuracy. Much of the text I'm going to be presenting on the slides is simplifications of language that's taken from the regulations or from official interpretive guidance. So I am going to follow the slides pretty closely to ensure consistency with the U.S. Department of Justice and U.S. Department of Health and Human Services regulations and their interpretations. As we go through, I will add context and examples to elaborate and illustrate things. Following the slides closely also maximizes accessibility for viewers and listeners who have a disability. And so that's part of what I'm doing in following the slides closely is modeling, giving an accessible presentation. And this will also result in an accessible video recording of the presentation. I would invite you to feel free to ask questions at any time. If you bring up a question and it's something I'll get to later, I might just say, that's a great question. Let's hold on to that for a minute and I'll get to it. The questions asked during the presentation will be part of the recording though. And so if you would prefer not to be in the recording, you can hold your questions until the end. And then after the recording is finished, there will be additional opportunity to ask questions. Just a few disclaimers considering the legal nature of the content we're covering today. I am a mental health professional who specializes in various things, including disability accessibility. I am not an attorney. So what I am doing today is providing technical guidance, not legal advice. It's also important to understand that this presentation is not comprehensive. While I am trying to cover the principles thoroughly and address the implications in depth, there are too many possible applications for me to be able to cover everything today. But so this presentation is not comprehensive, but we will cover this topic in a lot greater depth than some other presentations I've seen out there on this topic. So why a new accessibility rule? Why is the U.S. Department of Justice publishing this and implementing these technical standards? Well, when we think of disability accessibility, we often kind of default to thinking about physical access. But the Americans with Disabilities Act, or the ADA, also requires equally effective communication access, and websites and mobile apps are a form of communication. When we have inaccessible web content, that means people with disabilities are denied equal access to that information. And an inaccessible website can exclude people just as much as steps at an entrance to a physical location can exclude a person who uses a wheelchair. These barriers on websites keep people with disabilities from accessing information and programs that businesses and state and local governments make available to the public online. A key ADA accessibility case involved blind citizens who were unable to access current public transportation schedules through a city's website or by any other means that city used to make that information available to the public. And so this illustrates the importance of government programs, services, and activities being fully accessible to all citizens, regardless of disability. So that's a responsibility and an obligation that we have in government, is to make sure what we're providing is fully accessible to anybody who needs to be able to access it. Congress originally enacted the ADA in 1990, and Congress intended for it to keep pace with rapidly changing technology. Beginning in 1996, the U.S. Department of Justice has consistently taken the position that the ADA applies to web content. They've entered into numerous settlement agreements with state and local governments and with private businesses that include web accessibility requirements, and they've issued guidance several times in an effort to get entities to improve the accessibility of their web content. Unfortunately, providing this guidance and enforcement and expecting voluntary compliance with an undefined web accessibility standard, just simply saying that it had to be accessible, has not been very successful in getting governments and businesses to bring their websites into the level of compliance that's needed to truly ensure equal access to people with disabilities. So that's why the Department of Justice is moving forward with this new web accessibility rule. So who is required to comply with the rule, and when do they need to be in compliance by? So to understand this, it's important to understand that the new web rule is published under the Americans with Disabilities Act, or the ADA. Now, the ADA has 4 titles. We're going to be focusing primarily on Title II, but it's important to understand the difference between Title II and Title III, because both titles require web accessibility, but who has to comply is different under each title, and the standards that need to be met are a little different under each title. So Title II applies to all services, programs, and activities provided or made available by public entities. And a public entity is basically any state or local government. That includes any agencies, departments, or districts of those governments, or any instrumentalities of those governments. Title III, on the other hand, applies to what's referred to as public accommodations with respect to the operation of a place of public accommodation. And a public accommodation basically means a business or nonprofit that serves the public. So under Title II, well, each title contains similar overarching requirements. So under Title II, public entities must ensure equal access to all programs, services, or activities that they provide directly, or that they make available through contractual licensing or other arrangements, including those offered on the web. Similarly, under Title III, covered entities must ensure equal access to all goods, services, facilities, privileges, advantages, or accommodations that they offer, again, including those that they offer on the web. Under both titles, they're required to provide equal opportunity to participate or benefit from whatever is provided. Under both titles, they have to provide equally effective communication, although under Title II, they're required to give primary consideration to the request from the person with a disability as to how to communicate, whereas under Title III, that business or that public accommodation decides how to provide equally effective communication as long as the result is actually equally effective communication. Title II entities must comply with this new web rule we're covering today. Under Title III, their websites do need to be accessible to the extent that they're being used to provide a public accommodation, but they have flexibility in how to ensure their websites are accessible as long as the actual result is an accessible website. And keep in mind that websites are a form of communication, and so that's part of how web accessibility is covered under the ADA. Now, I mentioned that under Title II, these requirements apply to things made available through contractual licensing or other arrangements. The scope of Title II is that it applies to anything a public entity does. Now, there is kind of an exception for employment because employment is covered by Title I of the ADA rather than Title II. So it's not that employment isn't covered at all, it's that it's covered by a different set of requirements that are outside the scope of what we're covering today. But Title II otherwise does apply to anything a public entity does, even if it's carried out by contractors or others on the public entity's behalf. For example, a state is obligated by Title II to ensure that the services, programs, and activities of a state park inn that's operated by a private vendor under contract with that state complies with the state's Title II requirements. Now, regarding web rules, this means because it doesn't extend to employment, the web rule does not cover intranet sites, internal webinars and web meetings, internal learning management systems, and other things like that that are only for employees of the public entity and that can only be accessed by those employees. Keep in mind, though, that for Missouri state agencies, all of these employment things are covered by state law and the state ICT standards. So there are other applicable requirements that say those things have to meet technical accessibility standards, but that does not fall under the ADA Title II rule that we're covering today. It's also important to understand in relation to things made available through contractual licensing or other arrangements that the ADA expressly prohibits Title II entities from escaping liability through contract. So a public entity cannot delegate away or escape liability through contractual or other arrangements. The ADA expressly says a public entity may not directly or through contractual licensing or other arrangements utilize criteria or methods of administration that have the effect of subjecting qualified individuals with disabilities to discrimination on the basis of disability. This means public entities can be held liable for things that have a discriminatory effect, even if that was unintentional, even if the public entity was unaware, even if it was the result of following a business model, and even if it was done by a third party, if it was done under a contractual or other arrangement with the public entity. Now, a new web rule has also been published under Section 504 of the Rehabilitation Act. So we're going to talk about that just a little bit as well. Section 504 applies to any recipient of federal financial assistance, whether that is extended to them directly or through another recipient. And federal financial assistance is any arrangement by which a federal department provides or otherwise makes available assistance in the form of funds, services of federal personnel, real and personal property, or any other thing of value by way of grant, loan, contract, or cooperative agreement. And this includes Medicare and Medicaid payments. So this does extend to medical providers and healthcare providers that accept Medicare and Medicaid payments. Guidance on the Section 504 rules say that when the recipient contracts out responsibilities under the grant program or disperses the funds to other subgrantees that will also operate the program or activities, these statutory and contractual obligations pass down to the subgrantee or the contractor. So both the grantee and the subgrantee would be required to comply with Section 504. Guidance also says that when a state Medicaid agency provides Medicaid funds to managed care plans to manage and operate specific Medicaid programs or activities, those managed care plans are also subject to Section 504. Now, under Section 504, each federal executive branch agency publishes their own Section 504 rules for their recipients. The new Section 504 web rule that was recently published was published by the U.S. Department of Human Services. And that is the only federal department that currently has that web rule in their Section 504 rules. Now, if the U.S. Department of Justice decides to adopt the web rule in their Section 504 rules, then all other federal agencies would be required to adopt it in their rules as well. So far, that's not the case. Just keep in mind, right now, if you're a recipient of federal funds, the Section 504 web accessibility rule only applies to you if you're a recipient of federal funds from the U.S. Department of Health and Human Services. But it's quite possible that in the not too distant future, other agencies will publish rules that means this would be extended to other recipients from other departments as well. Now, the Section 504 rule from Health and Human Services in terms of the web and app accessibility requirements is really the same as the title rule, with one exception, and that is that it extends to require kiosk accessibility as well. But otherwise, we're not going to really address it separately because the requirements are the same as the Title II rule. Now, while this section focuses on who is required to comply, I do need to give you a bit of a preview of what content is covered by the rule, because it's important to understand when third parties need to comply, even if they're not directly covered by the Title II or Section 504 rules. And so we're going to jump ahead just a little bit here. Now, for simplicity, when I refer to public entities, keep in mind that these requirements also apply to recipients of federal financial assistance from the U.S. Department of Health and Human Services under the Section 504 rule. So the requirement it says that public entities shall ensure that the following are readily accessible to and usable by individuals with disabilities: web content that a public entity provides or makes available directly or through contractual, licensing, or other arrangements, and mobile apps that a public entity provides or makes available directly or through contractual, licensing, or other arrangements. This extends to content created or hosted by third parties. The requirements apply regardless of whether the content is located on the public entity's own website or mobile app, or elsewhere on the web or in mobile apps. It includes content posted by a third party due to a contractual, licensing, or other arrangement with the public entity. It includes content posted by or on behalf of a covered entity, including content embedded in a website from a different website or source. It includes third-party content posted by the public entity as well. So some examples include a survey on Qualtrics or SurveyMonkey or a different website like that. It would include a PDF document from an outside entity that the public entity posts on the public entity's own website. It would include a third-party app that's used to communicate with parents of students or distribute newsletters from a school district. It includes embedded third-party content such as videos, calendars and scheduling tools, maps, or reservation and payment systems. So these are things that a public entity's website might have embedded in them as part of the program, services, or activities that they provide that the public would need to use to fully access and participate in those. Now, there are exceptions for linked third-party content if the content is truly unaffiliated with the public entity. So if instead of taking that PDF document that you found from a third party and posting it on your website, if you just link to that document on that third party's website and that third party is unaffiliated with your public entity, then you are not responsible for the accessibility of that linked third-party content. There's also an exception for content posted by a third party on the public entity's website, unless it's posted due to a contractual, licensing, or other arrangement with the public entity. However, in this case, the platform that allows the posting of the third-party content still must be accessible, even though the content itself is not required to be accessible. And if that public entity receives a request from somebody with a disability to provide that inaccessible third-party content posted on their website in an accessible format, they may need to do that upon that request. So some examples of exceptions would be things like third-party legal filings, public comments posted on a public entity's social media account, student discussion board posts where there's an online student discussion forum. If an individual student posts content, that content would the public entity would not need to automatically make that content posted by the other students accessible, but the discussion board itself would need to be an accessible platform to students with disabilities. And if a student has a disability and requests that content in an accessible format, the public entity probably would need to provide that upon that request. This requirement also extends to situations where recipients provide or make content available, even when they do not design or own the content, if there's a contractual, licensing, or other arrangement through which they're using the content to provide a program, service, or activity. So if they're choosing to rely on third-party content for these things, they have to select third-party content that meets accessibility requirements. This is because, again, a public entity may not delegate away its obligations under the ADA. So some examples here would include a third party using a third-party parking app used by a municipality under contract to allow parking meter payments, a third-party document signature app that's used to complete application paperwork, the website of a contracted state park marina, or a contracted community mental health center, things like that. Now, if a public entity relies on a contractor or another third party to post content on its behalf, the public entity does retain responsibility for ensuring that the accessibility of that content. If they engage in contractual licensing or other arrangements with a third party to provide or make content available, the public entity can and should choose to work with providers who can ensure accessibility. And one way to do this would be to ensure that they include contract stipulations requiring accessibility and third-party services. But if they do that, merely requiring compliance by contract is not enough. The public entity also has to ensure that their contracts are carried out in compliance with the Title II obligations. So some examples would include a website developed for a public entity by a contracted web developer, an online advertising and social media campaign conducted by a contracted advertising agency on behalf of the public entity, or public awareness or informational materials that are developed and distributed online by a grantee of that public entity. All right, so that's who is required to comply. But now we're going to talk about the compliance deadlines. When do public or covered entities need to be in compliance? Now, there are different compliance under Title II and under Section 504. There are also different compliance dates depending on the size of the covered entity, and that size is defined differently under these two rules. So under Title II, if a public entity's total population is greater than 50,000, their content needs to be in compliance with the new rule by April 24th, 2026, which is 2 years from the date it was published. If the public entity's total population is equal to or less than 50,000, the compliance date is April 26th, 2027, so that's 3 years. If an entity is a special district government, then regardless of population covered by that special district government, the compliance date is April 26, 2027. So again, 3 years. Now, special district governments are government entities established for a limited single purpose or a set of related purposes. But this does not include independent school districts. Independent school districts are not considered special district governments. So if you're an independent school district, your compliance date would be based on the population, the total population within that school district. Now, under Section 504, compliance dates are defined by the number of employees. So recipients with 15 or more employees who need to be in compliance by May 11th, 2026, 2 years from the date of publication. Recipients with fewer than 15 employees have 3 years until May 10th, 2027. Now, keep in mind that an entity may be covered by both rules. And so a Title II entity with a population less than 50,000 would need to comply by May 11th, 2026, if it is also a recipient of federal funds from Health and Human Services and has at least 15 employees. So if you have 3 years under one, but 2 years under the other, keep in mind it's going to be that 2-year date where you need to be in compliance. And also keep in mind that the effective communication requirements under Title II and Section 504, including general web accessibility requirements, are currently in effect and enforceable. It's just the technical standard in the new rule that is not enforceable until the compliance date. What this means is that if you have web content or apps out there that don't meet the accessibility standards, not meeting that accessibility standard in and of itself is not currently a cause of action. But if not meeting that standard results in a discriminatory effect, that currently is a cause of action even before that compliance date. So do keep that in mind when you're strategizing as to how to come into compliance. All right, so what is the specific technical standard that must be met? The technical standard is incorporated into these rules by reference. It is the Web Content Accessibility Guidelines, or WCAG, or WCAG, version 2.1, levels A and AA. Now, WCAG guidelines have three currently published versions. One is 2.0, which was published in December 2008. So that's a bit older standard. Version 2.1 was published in June 2018, so it's just a few years old. Version 2.2 was published pretty recently, October 2023. So this was actually published after the notice of proposed rulemaking for these rules, which is one of the reasons why the rules use the version 2.1 standard. So just keep in mind, there are these different versions of the standard out there. And if you're Googling, looking up standards, do pay attention to which version of the standard you end up looking at. At this point, what's going to be required is 2.1, and that will be the case unless or until an update to the web rules are formally published incorporating version 2.2 or some future version. Now, there are also three different levels of these WCAG standards: levels A, AA, and AAA. Levels A and AA are the standards that are required to be met. Level AAA is kind of more stringent standards that are considered best practices that allow for access for people with multiple disabilities. So, for example, meeting level A and AA standards will make virtually all content accessible to a person who is deaf or to a person who is blind, but certain content would not be accessible to a person who is both deaf and blind unless you also meet AAA standards. But again, keep in mind, there are the general accessibility and effective communication requirements. And so that deaf-blind person can request that certain content be made accessible, and you may need to do that upon request, even though you're not required to do that in advance of a request or without a request under the web rule. Now, there is a bit of an exception for non-compliance that has a minimal impact on access. The rules say that full compliance with the technical standard is not required in the limited circumstance in which a public entity can demonstrate that the non-compliance has such minimal impact on access that it would not affect the ability of individuals with disabilities to do any of the following in a manner that provides substantially equivalent timeliness, privacy, independence, and ease of use. So if it has more than a minimal impact on any of those, it's not going to meet this minimal impact exception. Access to the same information as individuals without disabilities, the ability to engage in the same interactions as individuals without disabilities, conduct the same transactions as individuals without disabilities, or otherwise participate in or benefit from the same services, programs, and activities as individuals without disabilities. Now, minimal impact applies to the process and the user experience and not just to the outcome. So, just because it's not a categorical barrier to participating or doing something through the website, if it takes the person, more than minimally longer to do the same thing, then that would not be minimal impact, even though the person can ultimately achieve the same outcome as a person without a disability. The DOJ advises that public entities should not use this as a means of not complying with the technical standard. Rather, the reason this exception is in there is a safeguard so that an entity won't be found liable just because somebody finds a technical violation of WCAG. So if there's a line spacing requirement and you're just a little bit off, but that minor deviation doesn't have any practical impact, you're going to be okay. You're not going to be held liable just because there was this mere inconsequential technical violation. But keep in mind that this is an affirmative defense, and that means that the public entity has the burden of proof to show that the impact is minimal. So if you have content that's not in compliance with the technical standard, it is presumed that that has more than a minimal impact on some persons with a disability, unless you can prove that it does not. There's also an exception for conforming alternate versions. Some entities have attempted to skirt accessibility requirements by having a stripped down accessible version of their website that's separate from their primary but inaccessible website. Unfortunately, in practice, these websites often don't provide fully equivalent information and functionality, and they're often not kept up to date with the primary website. Now, the Americans with Disabilities Act does prohibit providing separate aids, benefits, or services to people with disabilities unless doing so is the only way to achieve equal effectiveness. But even when that separation is permissible, the regular aid, benefit, or service still needs to be as accessible as possible, and persons with a disability must be allowed, they have the right to choose which version to participate in, the regular one or the special separate one that's designed to be, fully equal and accessible. So in the same manner, the web accessibility rule limits the use of conforming alternate versions. And the separate but equal approach cannot be the default approach used to provide accessible web content. So a conforming alternate version is defined as a separate version of content that is accessible, up to date, contains the same information and functionality as the inaccessible content, and can be reached in particular ways, such as through a conforming page or an accessibility supported mechanism. So like we talked about under the general ADA standard for providing something that's separate, conforming alternate versions may be used to comply only where it is not possible to make the content directly accessible due to technical or legal limitations. And a developer or staff person's lack of know-how or the use of a third-party plugin or third-party embed is not a technical limitation. So just because your staff person doesn't know how to make a piece of content inaccessible, that doesn't mean that you don't have to make it accessible. If you need to bring in outside expertise to make it accessible, so be it. That content does need to be accessible. Now for schools, content that meets the National Instructional Materials Accessibility Standard, or NIMAS format, may be used as a conforming alternate version if the use of a conforming alternate version is permissible under the rule. So what content must meet the standard? Well, the content covered includes web content, which means the information and sensory experience to be communicated to the user by means of a user agent, including the code or markup that defines the content structure, presentation, and interactions. Now, a user agent means any software that retrieves and presents web content for users. So these definitions reference each other. Simply put, web content is defined as anything presented by a user agent, but user agent is defined as anything that presents web content. This means that the definitions are circular, which means that they're technically incoherent. I asked the DOJ, I asked some DOJ civil rights attorneys about this in a training they were presenting. Their response was that developers will generally know what the terms mean, but they may need to issue more guidance on this in the future to clarify it. So in most cases, I think it is clear what meets the definition of web content, but there are some unclear cases because of this circularity, and we'll talk about some of those in a few minutes. Some typical examples of web content would include text, images and animations, live and pre-recorded video, live and pre-recorded audio, web forms, links, buttons, and dialog boxes, data visualizations, and this also includes code or markup that defines the content structure, presentation, and interaction. So it's not just the visibly displayed content, it's also the underlying code and markup that needs to be accessible. Some additional examples that one might not so quickly recognize as covered web content includes things like customer portals, vendor portals, patient portals, telehealth platforms, parent portals, student portals, learning management systems, conference or event registration sites and apps, and videos live streamed to a website. It also includes conventional electronic documents, which is defined as web or mobile content in the following formats: PDFs, word processor files, spreadsheet files, and presentation files. Now, unlike most of the other lists we're covering in this presentation, this list of conventional electronic document formats is an exhaustive list. So conventional electronic documents does not include anything other than these particular types of formats. So it does not include database files. It does not include EPUB or electronic publication files or any other type of file not listed above. The rule also includes mobile apps, which is defined as software applications that are downloaded and designed to run on mobile devices such as smartphones and tablets. Keep in mind that the third-party requirements we already discussed apply to mobile apps and not just web content. The rule also applies to social media posts. So requirements include content that a public entity makes available via a social media platform. Now, the public entities are not required to ensure the social media platform itself is accessible because they don't have control over that, but only that the content posted by the public entity is accessible to the extent that accessibility features available on that social media platform they're using can make it accessible. Now, gray areas where it's not really clear whether certain types of content are covered by this accessibility rule, whether this falls within the definition of web content. So video live streamed via a video client, for example, WebEx or Zoom, listservs, group or mass emails, or pre-existing videos on a YouTube channel. It's not really clear how these are covered. Keep in mind, though, that if you send out a newsletter by listserv or mass email and you also post it on your website, that posting on your website needs to be accessible. So why wouldn't you also make it accessible in the listserv or email distribution just to cover your bases? The DOJ says that they encourage public entities to err on the side of ensuring accessibility where there are doubts about coverage to maximize access for people with disabilities. And keep in mind that even if these gray areas fall outside of the web rule, the Title II effective communication requirement still applies to all of these things. All right, now we're going to take a deeper dive on some express exceptions and the exceptions to the exception. So it's really important to pay attention to the details here because there are a lot of ifs. So there is an exception for archived web content. Archived web content is defined as content that was created before the compliance date or that reproduces paper documents or other physical media that was created before the compliance date, that is retained exclusively for reference, research, or record keeping, that is not altered or updated after the compliance or after the date of archiving, and that is organized and stored in a dedicated area or areas clearly identified as being archived. So to meet this definition, content must meet all of these criteria, not just one or two of them. Pre-existing conventional electronic documents are exempt. So this is content that is available as part of the public entity's web content or mobile apps before the compliance date, unless those documents are currently used to apply for, gain access to, or participate in the public entity's service programs or activities. So if you have an application form that's on your website in a PDF document, that might be pre-existing because you had it there before the compliance date, but if that's currently being used to apply for or gain access to your services, then that does need to be accessible by the compliance date. And then content posted by a third party is exempt unless posted due to contractual licensing or other arrangements with the public entity. Individualized, password protected, or otherwise secured conventional electronic documents are also exempt if they are about a specific individual, their property, or their account, and they're password protected or otherwise secured. Now, the platform or portal that's used to access these exempted documents must comply with the rule. It has to be accessible. But something like a water bill, lab test results, or a report card in PDF format that's password protected or otherwise secured would not need to meet the accessibility standard. Also, pre-existing social media posts, if posted before the compliance date, are exempted. Now, keep in mind that content is not exempt if it's password protected content that is not about an individual, password protected content that is not in a conventional electronic document, or third party content posted on behalf of or used by the public entity, like we already discussed. So examples of content that's not exempt would include a handbook, a notice of privacy practices, a syllabus, or other PDF document intended for multiple individuals, or a water bill, lab test results, or a report card that's presented in HTML format, even if it's password protected. For third-party content, I'd refer you back to our previous discussion. Keep in mind that a public entity may be required to provide content in an accessible format upon request based on existing Title II obligations, as we've already mentioned. Now, there is an undue burden or fundamental alteration defense that's available to having to meet the requirements. This rule says that where a public entity can demonstrate that compliance would result in a fundamental alteration in the nature of a service, program, or activity, or in undue financial and administrative burdens, then compliance is required to the extent that it does not result in a fundamental alteration or undue burden. And again, this is an affirmative defense. A public entity has the burden of proving that full compliance would result in such alterations or burdens. While there's no bright line standard for determining what is an undue burden or a fundamental alteration, these standards are very difficult to meet, especially in the context of effective communication requirements. Undue burden is not a cost-benefit analysis, and it's not a cost reimbursement analysis. Rather, it's an analysis in light of all available resources that the entity could use to make the content accessible. An example I like to use from case law is Johns Hopkins University Hospital extended an offer of employment to a deaf nurse. The deaf nurse requested that Johns Hopkins provide her with interpreting services, American Sign Language interpreting, to allow effective communication so that she could do her job. Johns Hopkins did an analysis and determined that because of the physical and mental fatigue associated with interpreting and the demanding nature of that they would need to hire 2 full-time interpreters to provide effective communication for the one nurse. So they denied that and rescinded their offer of employment, claiming that it would be an undue burden for them to hire 2 full-time interpreters. But court ruled that in light of the overall resources that Johns Hopkins had available to them, hiring 2 full-time interpreters for this one person was not an undue financial or administrative burden. Now, granted, that's a Title I example, but the undue burden standard is the same under Title I as it is under Title II in Section 504. So again, this is a very difficult standard to meet. The decision that compliance would result in such alteration or burdens must be made by the head of a public entity or their designee after considering all available resources and must be accompanied by a written statement of the reason for reaching that conclusion. So if an action would result in such alteration or burdens, a public entity is required to take any other action that would not result in that alteration or burdens, but would nevertheless ensure that individuals with disabilities receive the benefits or services provided by the public entity to the maximum extent possible. So again, this is an affirmative defense. The burden of proof is on the public entity to show that compliance would result in that fundamental alteration or undue burden. The decision must be made by the head of the public entity or their designee. The reason must be stated in writing. And even then, the requirements don't end. The public entity still has to do everything short of that fundamental alteration or undue burdens to achieve the maximum possible accessibility. All right, resources and references. The information I've covered today comes from and is based on 28 CFR Part 35, which is the U.S. Department of Justice's regulations implementing Title II. The web rule and commentary on that was published in the Federal Register, Volume 89, Number 80. It's also based on 45 CFR Part 84, which is Health and Human Services Section 504 regulations, and the HHS Section 504 web rule and commentary was published in the Federal Register, Volume 89, Number 91. Additional information is available at ada.gov/resources/2024-03-08-web-rule, ada.gov/resources/web-guidance, ada.gov/resources, and the technical standards themselves are available on w3.org/tr/WCAG21, and that is the WCAG standards version 2.1. All right, any questions?